Good morning to all of you. Welcome to Legal Matters by Sai Baba Sunkara. అందరికీ శుభోదయం. The main point I'm going to touch upon in this video is whether WhatsApp chats can be taken as evidence in a dispute between husband and wife by the family court. Simple issue, but a little bit complicated because there will be a conflict with the Indian Evidence Act. Right. Justice Ashish Shiroti of Madhya Pradesh High Court. Of course, case law is only X versus X like that. On 16th June 2025, held that WhatsApp evidence or WhatsApp chats can be admitted in evidence regardless of the privacy concerns. In the law of torts, I told you the subject of privileged communications. You may be knowing, suppose if a person comes to a lawyer and says that he has committed a murder, the lawyer as a dutiful citizen need not send him to the police station because the communication between lawyer and the client is confidential. Likewise, wife and husband in the Indian Penal Code are present Bharatiya Nyaya Sanhita, husband and wife are supposed to be one entity. The communication between wife and husband should not be disclosed to anybody, and basing on that, you cannot file a case. Of course, Supreme Court did not agree for it. So like that, Indian Evidence Act comes into conflict with the so-called WhatsApp chats. If you know the case facts, it will be better for you to appreciate the same. So let us, without wasting time, go to the brief fact of the case. The marriage, of course, this is a matrimonial dispute, and the court, the husband came to the family court by filing or by instituting a civil suit for the dissolution of marriage under Section 13 of the Hindu Marriage Act. The grounds are cruelty and adultery. Even though the marriage took place on 1/12/2016 at Gwalior, as per Hindu rites and customs, even though a baby girl was born on 11/1/2017, the husband has got suspicion about the character of the wife. So he filed a case of dissolution of marriage basing on the grounds of cruelty as well as adultery. Right. Now, in the pleadings, it's a civil procedure court case. In the pleadings, he cited WhatsApp chats of his wife with a third party as evidence to show her adulterous nature. WhatsApp chat of wife with a third person. How he got it also he has written in the pleadings. He has placed a special app in the wife's phone so that whatever messages she receives, they will automatically be transferred to which will forward to his phone. It is established through the material or WhatsApp chats that she has got extramarital affair. In the meantime, wife filed the counter stating that she wants to reside him and Section 9, restitution of conjugal rights. Now, the court asked them to produce evidence. At the evidence stage, the husband wants to mark the WhatsApp messages as exhibits. Right? Wife object to the same because they are confidential in nature. Second, he obtained them fraudulently, without her knowledge, against the right of privacy, all these things. But the family court allowed the evidence to be taken. Then the matter came to the agreed by this, the woman came to the High Court that such WhatsApp messages should not be taken as evidence by the court. Right? Because wife says installing an app in the wife's phone is illegal an infringement of our fundamental right to privacy. Evidence is such evidence which is collected is against to the spirit of section 43 of the IT Act. 43. If anybody intrudes, if anybody అవన్నీ చెప్తాం కదా అయితే సివిల్ కేసు అని చెప్తే అని కాంపన్సేషన్ ఉంటుందని చెప్పి ఐటీ యాక్ట్లో మీకు చెప్పాను 66 and 672 of the IT Act. So she plays reliance, wife argument, she plays reliance on a very famous case, Neha Garg versus Vibhor Garg నేను చెప్పాను ఇంతకుముందు 2021. But High Court says the family courts were established to tackle the sensitive matters, matters of privacy, custodial things, guardianship, dissolution of marriage, and custody, residential allotment. So many things are there. So, for the fair trial and public justice, such evidence can be taken. Because, no doubt, you cannot infringe into the personal rights of another person, privacy, but you may be knowing that the fundamental rights, they are not absolute rights. They have got reasonable restrictions. I told you in the case of Dr. Tokuga, Eptomi versus Apollo Hospital. The Apollo Hospital informed about his HIV status to the would-be father-in-law. Then he filed a case of medical negligence and giving information to the in-laws, as a result of which his marriage is cancelled. But Supreme Court held that in the interest of public justice, suppose if this matter is not divulged to the wife, what will happen? She would be contracted with HIV. So no fundamental right is absolute. They have got reasonable restrictions. And section 14 of the Family Courts Act, it provides court may examine evidence, court may receive evidence when what it thinks necessary to deal with the dispute. Even if it is not admissible by the Indian Evidence Act, just like I told you 122 to 126 of the Indian Evidence Act. Present section I have forgotten. Present అంటే ఏమంటారు భారతీయ సాక్ష్య అధినియమంలో సెక్షన్ చెప్పలేను కానీ ఎవిడెన్స్ యాక్ట్లో మాత్రం 122 126లో ప్రివిలేజ్డ్ కమ్యూనికేషన్స్ అంటాం. సో అవి నాట్ అడ్మిసిబుల్. బట్ అగెనెస్ట్ దిస్ ది ఫ్యామిలీ కోర్ట్ కెన్ టేక్ ఇట్ యాజ్ ఎందుకంటే ఫ్యామిలీ కోర్ట్స్ ఆర్ ఎస్టాబ్లిష్డ్ టు డీల్ విత్ ది మ్యాటర్స్ విచ్ ఆర్ సెన్సిటివ్ లైక్ రెస్టిట్యూషన్ ఆఫ్ కాంజుగల్ రైట్స్, legitimacy of the children, guardianship, custody and access to the minors. They are all very private, they are all very intimate, they are very personal, but still to appreciate the matter, to know whether it is fact or not, family court can take into such kind. For that matter, straight away I can tell you, family court is a lawyer akkarledu, advocate akkarledu, directly you can argue. So kabatti the sum and substance of the Family Court Act is to see that the families do not disrupt. For that person, they can, for that purpose, they can take any type of evidence. I think you are clear. Of course, with the advent of technology, WhatsApp evidence is definitely, it is admissible under section 65B of the Indian Evidence Act. But here the problem is regarding right to privacy. Whether husband can intrude into the mobile phone of his wife or not. అది ఎక్కువ సెన్సిటివ్గా తీసుకుంటారు. సో ఫర్ ప్రూవింగ్ ది సో కాల్డ్ అల్ట్రస్ బిహేవియర్ ఇట్స్ నెససరీ ఎసెన్షియల్ కోర్ట్ అలౌడ్ ఇట్. ఇది కొంచెం గుర్తుపెట్టుకోండి. కొన్ని సందర్భాల్లో జాగ్రత్త ఇలాంటివి చేస్తే భార్యలు దే మస్ట్ బి వెరీ వెరీ కాషస్. మోర్ దాన్ దట్ ఐ డోంట్ వాంట్ టు టెల్. ప్లీజ్ రీడ్ ది సబ్జెక్ట్ అండ్ టేక్ ఇట్ యాజ్ ఎ కేస్ స్టడీ అండ్ డెవలప్ యువర్ legal enthusiasm. Thank you.